to
decision.
protect my
I've
daughter.
made my decision.
And
Get
he
me
has a
the
warrant. You
order.
made this
I
decision knowing that he has a
okay.
warrant here in New York against me and my child. So
Arrest this woman.
And
I'm going to
Sanford,
appeal it because
that
he has already
if the
violated. He's already.
Imagine having a child with a woman, and then one day you guys get into it and things get really bad. And that's when she decides to file a harassment charge against you, meaning you might face jail time. Suddenly, you're not just fighting for your freedom, but you're also, remember, fighting for your right to even see your 2-year-old daughter. Why? Well, because in a lot of domestic disputes, one of the things that they do is put a no contact order in place. And that just doesn't mean no contact with the mother. It also means no contact with your 2-year-old daughter because she's 2. She doesn't have a phone. You have to go through the mother to speak to her. So while the case goes on month after month before you're convicted of anything because you're innocent until proven guilty, you're legally cut off from your child. Well, that's exactly what happened in this case. And all this father is requesting is a chance to see his daughter. Did his wife do all this on purpose? Is she vindictive? I'll leave that up to you to decide. The title of this video is entitled Mom Refuses to Let Dad See Daughter, Then the Judge Notices Her Game. No more wasting time. Let's get it.
A mother shows up in court determined to shut down her daughter's father, who is requesting to modify their no contact order so he can have visits with their daughter. But the whole time, she has their child's picture hanging behind her for everyone to see. The judge calls it out. And suddenly, everything shifts. What happens next? You won't believe how this one plays out. Stay tuned.
all right, good afternoon. Is Mr. Lots is with you in the at the
All right, so there we have something on screen, guys. As you know, I always read what pops up, well, most of the time. It says we have blurred out the very clear picture of their daughter behind her. So she had picture the daughter there behind her head.
computer, correct? All right. All right, so this is State of Georgia versus Benjamin S. Latta. Mr. Latta is represented by Mr. Moody, Bradley Moody, who's with him. This is case 2024 CR 00187. This is a motion to modify bond conditions. They are present, and the state is represented by Miss. Is this Miss Ponder or Miss Hafer?
Yeah, Sharon, I'm handling this case.
All right. Thank you. All right. So is the state ready to present?
Your Honor, the state is ready. I just want to get some clarification. It's my understanding, and counsel, you can correct me if I'm wrong. It's my understanding that this is on for a motion to modify bond so that Mr. Latta can have communications with his child. Is
Yep.
that correct?
That's correct, ma'am.
Okay.
All right. How old is the child, Mr. Moody?
2, Your Honor.
All right. And okay, so that's gonna make it a little difficult. What is the y'all tell me, what's the plan? Because
So
if
you
the mother of the child is the person who's the victim, alleged victim in this case,
that is
um,
correct, Your Honor. It is our understanding.
Guys, I hope you caught that. The mother of the child is the alleged victim, right? She's the one who's like, this man's harassing me. And due to that, of course, he can't contact his daughter.
That Miss Sanford, she is the mother of their 2-year-old child. And it's my understanding that Mr. Latta is requesting contact with his 2-year-old daughter via Zoom. It's my understanding that Mr. Latta resides here and the mother does not reside in the state of Georgia.
That's correct, Your Honor. The mother resides in New York. Currently, Mr. Latta and the mother of the child are going through the process of legitimation, or at least Mr. Latta is going through the process of legitimation in New York. And in terms of custody and visitation, we've an impasse in that the court in New York will not hear the matter of custody and visitation based off of the no contact order from here in Georgia in Clayton County. So we're trying to make some arrangement to allow where Mr. Latta would be able to ultimately have some sort of visitation with his daughter.
okay. Yeah, but this is complicated because the issue was harassing phone calls. The mother would have to facilitate the child getting onto a Zoom and manage that.
Right.
And what y'all are asking me for is to allow no violent or harassing contact limited to Zoom calls with the child. But that means that the mother has to manage it, and she's really not under my jurisdiction.
And Your Honor,
Yeah.
it's my understanding that Ms. Sanford does not want to have communication with Mr. Lotta. Is the reason, it's my understanding that counsel filed a motion to modify bond so that he can have contact with his daughter. As it's the state's position based on information that I did receive from Ms. Sanford, she's not comfortable with speaking to Mr. Lotta, and she does have the child. So at that point, the state will defer to the court.
And the legitimation action in the, I guess, whatever the family court is, in what part of New York is this?
This is in Queens, New York, Your Honor, and it's not a
So that would be
legitimation
the Supreme
process.
Court, right?
Yes.
I just want to make sure everybody's on the same page here. This lady is not a family court judge. She is a criminal court judge. She is in charge of the bond terms and conditions. Let's pause for a moment to thank the sponsor of this channel, FathersHaveRights.com. Did you know that prenuptial agreements are becoming significantly more common? Yes, especially among young generations like millennials and Gen Z. In fact, one of the expert attorneys featured in our prenup guide says he drafts 3 to 4 prenups every single week, and some firms draft more than 10. The truth is, far more people have prenups than you may realize. Want to know how to get a prenup before it's too late? Click the link pinned to the top of the comment section and take the first step in securing your future marriage and join the hundreds of men protecting their marriages the right way. For anybody who doesn't know what a bond is, when someone gets charged for something and they're pending a final conviction, they don't always go sit in jail. Sometimes they'll release them on bond, and that bond will come with conditions. In this case, the condition is no contact to the alleged victim. Sometimes, they could tell you to not leave the state, no drugs, no alcohol, no weapons. You have to maybe report to a probation officer, right? These are other probably familiar bond conditions that you guys have heard about. And also for you to show up to every court date. And so obviously for this father to be able to speak to his daughter, he would have to have the court modify that bond to allow that. And that's what he's requesting here.
Okay, so the Supreme Court in New York is not going to have, they're not going to even entertain the request for visitation legitimation unless I remove the no contact provision. Is that what I'm understanding?
That is my
That
understanding.
is correct.
That's not correct, Your Honor. That's not correct.
Miss
Ms.
Sanford,
Sanford.
give us
Ms.
one
Sanford,
moment,
hold
please.
on, ma'am. I'll hear from Ms. Sanford, but Ms. Sanford, hold on. Give me a minute.
This is pretty
'Cause I'm
common.
trying to understand, because some of this, I mean, I can say a lot of things. I order a lot of things, but Ms. Sanford is literally outside my jurisdiction. She doesn't live here. The child is in New York. The only person I have control over is Mr. Lotta. And
And
with
Your
that
Honor,
being said, I can order that Mr. Lotta can have no violent or harassing contact and limit it to Zoom or text. But as far as whether that happens, that has nothing to do with me.
well, yes, Your Honor, and that's exactly right. I completely agree with that. And the screen just went out. Can you still hear me, Your Honor?
I hear you.
Okay, sorry, the screen went out. So I completely agree with that, and that's all we're asking for is the relief to allow the court in New York to make that custody arrangement or make that visitation arrangement. So, I mean, as of right now, we're just at, I mean, we're at an impasse as to any progress in either of these matters. The case here in Clayton County or the family law matter in New York.
I get that, but the issue that I have is the action you're wanting me to allow is for him to make essentially phone communication with Miss Sanford for the purposes of seeing the child.
But you get him
Yes,
arrested.
sir.
alleged offense is based on harassing phone communications.
Right.
Yes, Your Honor, I understand that. I mean, this is an event from March 17th of 2023. At some point, and at some point, these two people are just going to have to accept that they do have a child together. I mean, he's not never see his child.
I get that. Here's the issue that I have
Yes, Judge.
is a lot of people have babies and children together without first thinking whether this is somebody they can stand over the long term.
Come on now.
And this is essentially what I keep getting, like it's not really my bailiwick. I'm state court. I don't have to do family law. Thank God. Because when I was a staff attorney in the family law division in Fulton County, I knew then that was not what I wanted to deal with because the most volatile practice is family law. That's where you give an inch, they'll take a month. If you say you can have a little bit of contact, then all of a sudden my words get weaponized and the judge said, and that's really not what this is because I can't order Miss Sanford to do anything. The only relief I can give is I'll say no violent or harassing contact. But the problem that I have is the contact that you wish to enable is what is the basis of the charge. And I just don't, I've never had a court with a jurisdiction over what I have say that they needed me to do something in order for them to do something. Here, if I say no harassing or no contact, a superior court can say, because they're a court of general jurisdiction, hey, I understand this order, but I'm going to order these specifics with respect to the no contact. I recognize it, but I can order this because these people are before me. The problem that I have here is even if I say this, I can't control then what happens. And if this leads to another offense of harassing phone calls, then I've enabled it.
Right.
I just want people to start thinking more about okay, it feels good right now, but do I really want to have a baby with this person?
Right.
Because these issues are coming up a lot.
And is it possible?
Let me hear from Miss Sanford for a minute. Miss Sanford, raise your right hand for me.
And you know for a fact that when it comes to the mother of this child, what she wants, successful court hearing here for her, is for the father to never talk to that daughter, his daughter, assuming that it is his daughter. Right now, she believes the best thing is for her. She's probably found another dude. She believes the best thing is for the father to never talk to the daughter. That's what she would love. She would love to make this just impossible.
Okay.
Yes,
Hold
Your Honor.
on, Miss Ponder. You
Yeah.
solemnly swear or affirm any testimony you give in this matter will be true.
Yes, I do, Your Honor.
All right. So tell me about your concerns, Ms. Sanford. Don't really go into the what happened, underlying offense, because I don't. That's not what's on the table. But tell me about me giving contact.
So I would like to first express I vehemently oppose. I'm not consenting to any access between Benjamin Lotta, the defendant, and is the 2-year-old, our daughter. As it stands right now, Your Honor, I have many pressing concerns. And what I'm surprised that has not been brought up already is that Mr. Lotta has an outstanding, and I'm going to be careful with my words because of how it's entered, but he has an outstanding warrant here in New York when he has been evading the police for the last close to 3 years by not answering that warrant. He has refused to come to in-person proceedings. His family court attorney makes excuses for him by just saying he can't come because he would get arrested. He has not tried to turn himself in. They have said that they cannot find it. But it has been stated on record several times. My previous attorney has been able to confirm he is a wanted person in New York. The terminology of it, with it being a warrant, it's not the exact terminology, but that it is an equivalent because the police department issued it and not the state. So that's why when you search it, it does not appear, but he is in fact wanted here in New York City for an offense here.
Isn't it funny how she keeps on bringing up he's a wanted man, he's dangerous. And this is the frustration that I'm sure the judge, she's grateful she's in a family court because she's looking at this like, yeah, this is the guy that you had a child with. You wanted this.
Now,
What they call it up there, a detainer?
no, it starts with an I.
Okay.
But he
doesn't.
is,
So you're objecting to any contact?
yes, but I have other concerns as well. When it
Well, let
comes
me
to-
let me satisfy what I need to know. The child is fully in your custody and control.
I have sole legal and physical custody of time. Yes.
Okay, there will be
And by the way, we don't know if she's telling the truth about that whole wanted thing, by the way.
nobody else who could facilitate the contact over Zoom but you.
No, because one, Mr.
Don't
Lana
have to
has
tell
made,
me why. If you have full custody and control and there's nobody else, that's fine. The less that the child's information is put out there, the better. I don't like.
I also want to just bring something else out there, that in family court, because I'm pretty sure this is something that Attorney Moody would be prepared to say today based off of other testimonies made. The defendant has made requests for social workers to do the I guess the Zoom exchange. Now, in the past, I have already consented to Zooms. I have signed stipulations granting the defendant access, but I withdrew it because one, he did not have Georgia's permission, and two, he was actually actively abusing government agencies during that process. And just to talk about my safety concerns when it comes to the defendant and the defendant has sworn under oath in a criminal trial in Fulton County that he instructed someone to call CPS with false allegations stating that I was going to kill my daughter. And this is in a
Okay, this is all
Either-
I need to know.
You're-
Ms. Sanford, you're
the
not
reason I'm
testifying
bringing- the
for this,
reason-
Ms. Sanford. I don't want to know anymore because what I don't
The reason
want
why I'm
is-
bringing that up is because I
But
don't want
Ms.
to
Sanford,
around my
this is what
daughter.
I'm saying.
She literally came into this court hearing with the intention of painting the father of her kids as much of a monster as she possibly can.
Is y'all start testifying whenever it's a family law issue, y'all start testifying for whatever the next hearing is. I don't need to know all that. What I need to know is whether it makes sense for me to grant the modification. I think I've heard enough where I'm not comfortable granting the modification. I think, what, Ms. Pond?
Is it possible if I can have a breakout room with the court as well as with defense counsel?
Please.
Okay, 1 second.
Hey, Judge James Fulton just checked in.
All right, Mr. Fulton, yeah. I didn't see Mr. Fulton's name on here, so he must be for 1 or 2 o'clock, so.
Relax, mama. Please go have a seat, baby.
Let's see.
Hold on, something was on screen there. Let's make sure we read that. All right, there it says, leaning over the daughter's picture on food display. And the judge is starting to notice all of this. And so there's some manipulation going on here. Listen to the way this woman is talking. This isn't somebody who is brand new to a court hearing, right? Speaking very confidently, trying to sound like an attorney. She's propping up the shot there with the daughter in the background. She's thought of all this. That's what I think. Maybe you disagree. Maybe you're like, Shisha, you kind of taking this to the comment down below.
Let's see. Okay, so I'm gonna put the courtroom and Ms. Ponder in breakout room number 1, and then I'll join. And Ms. Sanford, I'm not real comfortable with your daughter's picture being on. She's a minor, and this gets broadcast. You know, you got her picture up behind you. I'm not comfortable.
I'm so sorry. I thought her face was blocked because on my end, I can only see her
I
elbow.
can see both pictures.
Oh, wow. Sorry.
Yeah.
On my end, I put it at an angle where I can only
Yeah,
see.
I got you, but I'm, just not comfortable with that.
No, thank you.
All right.
I'm not either. Thank you. Thank you.
Right.
Is that all you see now? Because on my end, I was only ever to see her arms down.
Yeah, it's better.
Thank you.
And the issue is that both parents seem to lose sight of the fact that there is a vulnerable child in the situation. And it becomes very performative. Everybody's fighting and yelling and going at each other, and nobody, Miss Sanford, you can look at me all you want to, but I've been in this game for so long. The pilot program for Fulton County Family Court, I was one of the staff attorneys who helped to get some of the forms done, who sat through mediations, who trained extensively in family law, and then decided I never wanted to do it. Because what people do is they weaponize the child.
Uh-oh, she's catching on.
And they don't think, I work alone. If I need you, I'll let you know. They don't
Oof.
ever think about what it means to a child to
Get her.
have parents who fight continuously.
Mm.
Now, this is the issue. At some point, y'all thought it was a good idea to sit down and exchange bodily fluids and have a child. At some point, this person who's on the other side of the V made sense to you.
Mm.
Now, unless it was an arm's length transaction where this was done through a clinic or something, or this was a surrogacy issue, but I'm not getting that. I'm getting that you all chose to have a child as a child of divorce, and it wasn't even a contentious divorce. I will tell you that both of you, until you learn how to co-parent, are going to ruin your child.
That's why she didn't want to get into family court. It hits too close to home.
I'm
Makes
just going to
sense.
say it. You're going to ruin this child because she is going to understand that she has two parents. And if she's denied the time to be or the opportunity to be with one or the other parent, she's going to resent that. I grew up without my father in my life. And I'm going to tell you, I didn't resent my mother. I knew the circumstances, but I did resent that he wasn't present and I grew up without him. So what I tell you is at some point, you got to put your claws in. You got to have a little bit of humility and you got to listen and structure this in a way where y'all may never like each other. You may never deal with each other directly, but y'all have got to figure out a way where this child doesn't feel like half of them is not a good thing.
Mm.
The child is always going to know that they have a father and a mother. And if they don't have access to one or the other, it's going to hurt. Now, Ms. Sanford, you came on here and I'm listening to you, but as a mother, I would have
Yeah.
never shown my daughter's picture. I would have
That
never
was
said
not
your daughter's
intentional,
name.
Your Honor.
You
That
said
was
your
not
daughter's name
intentional.
multiple times. You've shown the picture multiple times. That to me is performative.
Mm.
Your Honor, may I just intervene because you made a
No,
few
shut
statements
up.
that are very inaccurate.
Y'all
First
didn't
and
choose to have a baby together.
first and foremost, let
Y'all
me
didn't
just
choose to have
make
a
it
baby
very,
together.
let me make it clear on
Y'all
record.
didn't choose to have a baby
I
together.
chose to have my daughter. He told me to have an, and I'm now, let me just start because we're going into things that's not relevant and I don't speak
No,
about these
Ms.
things until
Sanford,
in the
I'm
presence of
not
my daughter.
I'm
Your
not in
Honor,
family court. I'm not doing
Your
this.
Honor,
What I'm
I
saying to you
offered
is,
I heard
This chick looks familiar too. I'm not sure from where. She looks familiar.
okay, so to the extent that I am holding up the family law court from making a decision in this case, I will grant a very limited
Your Honor, may I
modification.
please
Ms. Sanford,
mention what I was going
Ms.
to say?
Sanford,
You
Ms.
made some
Sanford.
statements and I would like to
I will grant a very limited modification of my order. It is to be no violent or harassing contact, no direct contact. Any contact will be subject to text messages. If there is Zoom contact, the Zoom has to be recorded so that there's a record for the court. No physical contact, no in-person contact.
I'm going to appeal it.
You can do whatever you want to, Ms. Amber. No
We had
physical
5
contact.
Notice how we just saw the judge in real time change her mind. She literally said, I think I have everything I need to not approve this. Then she sees the photo. Then this woman is combative, disregarding everything she's saying, right? This is somebody who's not as, you can tell, not as disillusioned with family court because that's not where she works. And so she is coming at this from a more human side instead of the people who are just like, hey, be quiet. This is what it is. And they're just fed up with the whole thing. But she talked herself into the situation.
negotiations that he declined.
So that the family law court in New York can make a decision, because I don't have jurisdiction over family law. My jurisdiction is literally limited to this particular misdemeanor offense in Clayton County, Georgia. With that being said, Mr. Lanta, let me explain to you outside the very narrow confines of what I've ordered. Let me explain what happens if you violate. The possibility exists that you could have your bond revoked and you could remain in jail here in Georgia in Clayton County until your case is tried. It also, there also is the possibility that you could be charged with additional misdemeanors or felonies, particularly the felony of aggravated stalking, which is punishable by up to 10 years in prison, a $10,000 fine, or
Damn.
both. I'm not just giving you these cautions. Everybody who has a bond and a case where there is a victim on the other side, and it's not a traffic offense, I go over these bond conditions and the issues of bond with them. So with that being said, I will limit contact to text, to Zooms if they're recorded, and no in-person, no telephone, nothing that can't be seen by or reviewed
She's
by a
heated.
court. No, that is the limitation that I have, so that the family law court in New York can address these issues and can make a determination that might be permanent between these parties,
And
because
Your
I
Honor-
don't have jurisdiction on that.
Your Honor, it has been suggested in the family law court in New York, the possibility of having some physical contact as supervised.
No,
by a
That has
social worker.
never been
Look,
discussed. That has
look,
never been
listen,
discussed. And I'm not
I've
getting
done-
You gotta love that dude's lawyer. He's like, they gave us an inch. Let's take him out. Let's take him out. That's why you need an attorney. That's why you need an attorney if you can afford one. It's worth it.
I'm
all
not
that-
getting the opportunity to speak. That-
I've done all that I can do. I would presume that a superior or Supreme Court in New York, which has jurisdiction over family law, can make whatever decision they want to make. And at some point soon, I hope, this case will be tried or resolved through a plea, and my jurisdiction over these individuals will, or this individual will end. And so my decision is limited by the fact that I'm not holding this case forever. If you talk to the state and y'all can pre-try this case and y'all get it resolved, that's fine. If we put it on a trial calendar that goes to trial, that's fine. But I'm not going to have the level of oversight over these parties that the family law court will. So they can do what they want to do.
Mhm.
I won't be offended, promise. I promise you. So with that being said, draft the order. I'll sign it and get both copies to both parties.
Your Honor, may I please clarify one
Oh,
statement?
shit.
What statement, Ms. Chair?
Thank you, Your Honor. I want to make one thing clear, because you did give us a well-needed lecture, but I want to make one thing clear. The defendant was offered not one, not two, but 5 custody and visitation negotiations from me when I was pro se and represented. He declined all of them. And we're talking about over the course of 3 years, the child is only 2. I have also signed 2 stipulations for him to
Your Honor,
have
we're so
access to the
far
child.
back.
Let me speak, please. I have signed 2 stipulations for him to actually have access to the child. He never asked permission from the state of Georgia to get it. So it's not performative. There are things that has happened between then and now where he has put my child and myself at safety doing background checks to find our address.
Take your L. Take it. It's over. It's done. He's going to do Zoom calls.
Making police reports. He's made
Your Honor,
threats
may
to
we be
my
excused?
fiance, all things that has done between then and now. It's not performative. And if anyone, I don't need
Ma'am,
anyone
I didn't
to
say
check me
that
out.
was performative.
Well,
I
nothing
said
is
putting your
performative.
child's
If my
name and
screen is
picture.
this big, my screen is this big, and from here, I can only see her elbow down. I protect my daughter very.
Okay, so I made my decision, and
And
that's what
I
I
will go
said.
to any length at anyone's
I
expense.
made my
to
decision.
protect my
I
daughter.
made my decision.
And
Get
he
me
has a
the
warrant. You
order.
made this
I
decision
will-
knowing that he has
Okay.
a warrant here in New York against me and my child. So
Arrest this woman.
I'm
Ms.
going to
Sanford,
appeal it because
the-
he has already
if the-
violated. He's already
Ms.
violated the
Sanford,
New York
if
order
they
of
wanted to
protection.
exercise the warrant, they would.
Yeah,
New
he has
York
not
can do
commenced.
that.
He's been evading the police, Your Honor, this entire time. He has a
Ms.
warrant here
Sanford,
for a crime
Sanford.
committed against
Your
me
Honor.
and my child.
Ms. Sanford,
Wah, cry baby. What is going on?
you're
My
not gonna
Me and
win.
my daughter.
Ms. Sanford, there's nothing to win here.
It's
Stop.
not winning. I
Stop.
want to protect my daughter.
Stop.
And you said it was
Stop.
performative. I am protecting my
Stop.
daughter.
There's
And you said it
nothing
was,
to win here.
it's
there
not
is no win
performative.
here.
I'm protecting.
Hold on, guys. Check this out. Look right there. They walk away. He's like, hold on, man. We don't have time for this shit.
I want
Stop.
to protect my daughter.
Stop.
And you
Look at
said it
that.
was
Stop.
performative. I am protecting my
Stop.
daughter, and
There's
you said it
nothing
was,
to win here.
it's
There
not
is no win
performative.
here.
I'm
You will not protect her here.
yes,
This
I
is what
am.
I've said. I've done what I've done. Get me the order.
And I'm
I
going
don't
to
mind.
appeal it. You
Hearing-
did this knowing he has a warrant.
I'm not
called
scared
it
of the appellate court.
performative.
Let's hear
Shut
it.
up.
All right, hearing over.
For the things that he has done
Hearing
already to
over.
me and my child.
Hearing over.
And I will.
All right.
And people are so surprised when a woman like that gets checked or sent to jail. They wonder, why do men cheer? Because nobody ever truly checks one of these entitled, bitter mothers. And once in a while, they get to drink coffee. She got a few of these comments, see what the people have to say. Top comment here says she hates him more than she loves her child. This next comment here says he can't see the child on Zoom, but the internet can. Girl, bye. Another female commenter here says the fact that the mother is talking about this in front of the child and allowing the father to hear her in the background is cruelty. This commenter here responded back to that comment and said, that was my main issue with her. As legitimate her concerns are, she should never speak ill of the father in front of the daughter. It says a lot about her. Exactly. Somebody else here says women who use their children to hurt the father should go straight to jail. Period. Another person here added, take a shot every time she says, it's my understanding. Somebody else here added, I work alone. If I need you, I'll let you know. I love this judge. Here's somebody else who says, if the father had acted like this, he would have been held in contempt of court. They would have arrested that man so quick. This commenter here says, now, if the man says, F this, I'll just pay child support and see the kid once she turns 18, people would call him a deadbeat. Ladies, stop hating the man more than you love your children. Now, the same commenter had to come back and edit her comment and leave an update because, people started whining and crying and going, well, are you saying men should leave their kids? This comment here says, update, for those of you that think my comment is condoning a man walking away from his kid because the mother is difficult, it's not. I simply made a comment that I would see a lot of people make if the mother was consistently making it difficult for the father. I believe no matter what, you should love your children more than you hate the other parent. You picked them, and now you have to deal with your choices, but your child is the most important person in your life. I agree. And one of the things I appreciate about reviewing these court hearings is I'm learning a lot about what you don't know when it comes to experiencing this. And I mean like practically for a man, what it looks like. A woman possibly lying on you, you facing jail time. Like how much are you willing to fight? Well, this father is willing to fight to see his children. But there's no way you can see entitled moms act this way and not tell them that you can make it easier for that man to walk away. Or you can make it harder for him to walk away and actually encourage him by the way that you carry yourself. Of course, guys, curious to know what you think. Hey, guys, as always, I appreciate you checking out yet another episode of the Coffee Pod. To my currently engaged or soon-to-be married men, if you need a prenup and would like a guide that shows you how to get a solid and legally binding prenuptial agreement, hit the link into the top of the comment section and access your guide at fathershaverights.com today.